Hynes, former Commissioner, Body Corporate Community Management, Strata Consultant, Hynes Legal. With me today, as always, Frank Higginson, partner, Hynes Legal, from an undisclosed location. Frank, welcome.
Doing the tour on the Gold Coast to see all of the new developments that are well and truly arriving down here. It's extraordinary the amount of cranes in the sky. But no, on holidays, but ringing in for this.
Well deserved. And see, look, people think that we do this in a slapdash fashion, but there's dedication for you. Gold Coast holiday and logging in for webinars. If that doesn't demonstrate to you commitment to the cause, everybody, I don't know what will. But anyway, enough of that. As always, if you have a query, we'll try and get to as many of those as we can today. You can ask those live. If your query is a bit more involved, we suggest that you put your query into the form, which will be appearing in the chat section very shortly, and we'll do our best to get back to you as soon as possible on that. Today, exclusivity, property rights usage, common property rights usage to be exact. Pretty common topic, isn't it, Frank? And one that causes a bit of consternation, doesn't it?
Oh, it's enormous. You know what I mean? It's sort of, and when you go through the different ways that people get the right to use common property, I suppose it starts with common property by its very nature is common to all owners. I mean, who would have thought? And inside that then, giving away the right to use that exclusively or non-exclusively for a period of time is a relatively big thing in strata land. It's enormous. So, and you do get lots of, probably there's a bunch of these webinars we could do around this. So I think today is a bit more of an introductory one across the different types, and then we might delve into some more of the details in due course. But it is a big thing, and there's lots and lots of inquiry about that we get every other day because of the nature of what it is. It's sort of, that's mine, and now it's yours, and how did that happen?
Well, it kind of, in a way, goes against the fundamentals of being in the body corporate, doesn't it? That the common property is everybody's, proportionate to their share in it. And so now you introduce the idea that, well, in fact, you can have use of the common property that is yours and only yours to the exclusion of somebody else. And I'm guessing that for some people, that's a concept that doesn't sit terribly well sometimes. And for somebody's corporate, that's probably not a concept that sits terribly well. But let's as you say, Frank, let's go through how it happens. I guess the first thing to note is that because you are, in effect, giving away what is everybody's, the way in which you give it away usually is a really high threshold, isn't it?
Absolutely. It's almost never at committee level. Actually, no, I can quite safely say it's never at committee level. And if it's permanent, it's always going to be resolution without dissent. And so again, remembering resolution without dissent is not everyone voting in favour of something. It's no one voting against the proposal. So again, an example of 100 lots, one in favour, none against, on a resolution without dissent, that's passed, as much as that's probably unlikely in some of these situations. And then, mate, I suppose the other thing is, what is common property? Again, this is what we do a lot of legal advice on. And I think for those of you that have, it really, probably the simplest way to describe it is anything that's not inside your lot is common property. So when it starts, we've got a building, we've got a parcel of land like this one that I'm in here, and that's my daughter slamming cupboards behind me. So if you don't do that, that'd be great, please. You've got a parcel of land, and on that goes a high rise, for example, like the one I'm in at the moment. So, and that airspace is subdivided in individual lots. And so when you look at the survey plan or the building format plan that created the lots, there's a dark black line, and that is the boundary of the lot itself. Inside that dark black line is yours. Outside that, other than inside other people's dark black lines, is common property. So that's gardens, grounds, pool, lifts, foyers, stairwells, usually garage space and those sort of things. But it sounds simple in theory. Sometimes it's hard to demarcate at times, but that dark black line is the thing you're actually looking for.
So you've done that, you've gone through that process, and you've figured out more or less what's common property, what's not. Let's talk about how you get it exclusively to be yours then. And the first way, and possibly the most complex, even though the concept is the simplest, is you actually buy it. You can buy common property, Frank?
You can. You absolutely can. So And that, in a sense, because the body corporate, as much as it can't operate a business, it is well and truly capable of disposing of body corporate assets, and common property is a body corporate asset in that sense, the same as tables and chairs by the pool are. It can sell those things. So when you're talking about common property itself, you can absolutely carve off. And let's say, for example, we've got, again, the high rise I'm sitting here at the moment on holidays, you've got a ground floor unit with an area outside that is grass. So ordinarily that would be exclusive use, and we'll deal with that a little bit later. But say, for example, that it hasn't actually happened. So it's just grass, everyone can use it. What can happen is the body corporate can agree to effectively subdivide its common property into 2 lots. Here's the balance lot, and here's this little bit of area that is the courtyard. And then it can agree to transfer that to the owner of that courtyard lot to form part of the title to their lot. So, so while this can happen, it's pretty rare in the sense because there's easier ways to achieve the same outcome. Because when you're talking about the sale of common property, so you've got to start with it's a resolution without dissent.
Yep.
That's number one. You need to do a whole bunch of new survey plans, titling documents. So we've got to split off that parcel of land from the common property. We've got to create a separate title for a period of time. And usually what will happen is when that new lot is transferred to the ground floor owner, they want to amalgamate it with their lot. So they don't have 2 separate parcels of land. So they don't own lots 1 and 2. They've got lot 1 that incorporates that land itself. So you've got a whole bunch of surveying type stuff. You've got stamp duty, because what the body corporate's doing is selling. So the buyer is going to pay stamp duty on that. Of course, then you've got valuation issues. What's it actually worth? Which is an interesting thing. So the way the stamps office works, stamps office, that's old school, Office of State Revenue, is that stamp duty is payable on the consideration or the value, whichever is the greater.
Sure.
So what normally happens is between parties at arm's length. So if Chris agreed to buy my house, the Office of State Revenue will take the purchase price that we've agreed between us as market value because we're not related parties. In a body corporate context, it might go down to 0, but it's actually not worth 0. It's worth more than that, because the reality is that land has some value. So sometimes you might need valuation evidence to go with it. You need a new CMS because we're changing the nature of some of the title descriptions in Schedule B, which we spoke about last week or the week before. You've got to look at lot entitlements. Interest schedule entitlements probably should change. Contribution schedule entitlements, question mark over those. Town planning, council will normally have to get involved to seal those plans. If the person on the ground floor that's acquiring that has a mortgage, they're going to need their mortgagee's consent to it. And again, that's a process. And then, of course, you actually need to do the conveyance. You physically should enter into some form of contract and have that approved at general meeting. And because it's a contract at the time, usually where it's approved, if the body corporate is subdividing the land off, you're going to enter into effectively an off-the-plan contract because that title or that particular block of land doesn't yet exist. Exists in theory because that's what we're doing. We've got a plan of what it's going to look like, but we haven't gone through the process to actually subdivide it. So effectively, it's a sort of off-the-plan conveyancing contract. So when you add all of that into the mix, that is why that doesn't happen all that often. It's possible, and we absolutely have done it, but it's a really not difficult, laborious process to actually get to where you need to go.
A lot of strands involved in that one, which probably explains why it doesn't happen as commonly as the next thing we're going to talk about, which is exclusive use. And I think it's fair to say when people talk about getting usage of common property, it's usually under an exclusive use grant. That's usually how people come to terms with it, understand it, and how it operates in practice.
Yes.
How about we cover off some of the exclusive use 101s to kick things off? So it attaches to the lot. So even after sale, it stays with that lot until such point as it's removed by another process. It gives the occupier for the time being the exclusive use in the form of a bylaw, and then it's allocated in Schedule E. Where does Schedule E come from? It comes from your community management statement, which you were hopefully watching our webinar about that the other week. The owner must agree in writing, and then it must pass by resolution without dissent. But usually all of that is in place, so it just happens. Obviously, someone is not going to get exclusive use if they don't agree to it. It wouldn't make any sense for it to work that way. That also, of course, Frank, applies to stopping exclusive use. And here is a good tip for everybody. Whatever happens in a body corporate can also be undone the same way it happened in the first place. So if something got passed by ordinary resolution, it can get undone by ordinary resolution. Same thing here. Process for undoing EU is the same as approving it effectively. Fair call there, Frank?
And in terms of undoing an EU, is
Yep.
It won't happen unless the owner of the lot actually consents in writing to it or votes in favour of the resolution itself. So, as a resolution voting against something, taking away an exclusive use right still needs the same resolution, but the owner must physically consent to that. So it can't happen unless they agree.
Yep, good point, Frank. Important to note about exclusive use that regardless of whatever it is, an exclusive use cannot give rights over utility infrastructure, which is common property, or an asset, and it can't prohibit allocations under reallocation agreement. So you cannot give exclusive use to utility infrastructure. I mean, that's pretty common sense when you think about it, I guess. I reckon that we could probably, and we've lost Frank there. Frank, are you still with us? You are?
Sorry.
Happy days.
I'm back. No,
Yep.
I had something appeared on my phone, which I'm doing this on, and I clicked on that to get rid of it, and I disappeared, but I'm back. So then my heart can stop there.
It definitely was not a cocktail with an umbrella in it.
No.
Look, we could do an entire webinar about EU, and we probably will follow up this one with an EU dedicated webinar at some point, because there's a whole other discussion to be had about maintenance responsibilities under an EU bylaw. I think we'll leave that for another time. It's fair to say, Frank, the most common EU is car parking, isn't it?
Yep, absolutely. And then probably those courtyard areas I mentioned before, and maybe some storage cages. And usually they're granted off the plan. So what happens is when you buy a unit off the plan, you're going to buy lot 501, and then in the basement normally you'll have a bunch of car parks and whatever else that might be allocated to that unit. So when we're talking about owners granting and consenting to removal and those sort of things, that's really for existing buildings. For buildings that are off the plan, it is, well, every time the developer will put all of those things in place. And after that, then people can transfer them around and do whatever they want with them. But so it's rarer, and probably where we tend to get involved in exclusive use. Occasionally it pops up, new car parking, new areas, all that sort of stuff. More often than not, we tend to help bodies corporate and lot owners where people have appropriated common property, thinking they've got the exclusive use to it by mistake. So we get a whole lot of that with car parks, particularly with sort of building in, just because you're in a townhouse estate doesn't mean necessarily you're not a building format plan. And what that means is that the boundary of your lot is that dark black line. People will go and build things beside their lots thinking it's theirs when it's actually not. So ratifying, in a sense, those things is a process, which the only way to really cure it is exclusive use. And again, you could do that purchase process. You absolutely could, but the granting exclusive use for an existing building is relatively simple in terms of you've got to have the right plan to identify the area, because the Titles Office or Department of Energy, Resources and Mines, DERM, is pretty specific around what they want in terms of plans. You can't simply sketch something yourself. You're much better off getting a surveyor to draw these things that has the right dimensions and areas and peg points and all that sort of stuff.
Yep.
And you then put up a motion by resolution without dissent to grant the use of that area in accordance with that plan, and for the body corporate to then amend the CMS, and it's done. Same resolution type, resolution without dissent. And so when you look at that purchase process versus granting an EU, it's a hell of a lot simpler to grant an EU, and you almost achieve the same outcome. Like I'm not a valuer by any stretch of the imagination, but I've never really seen a valuer apply a discount to an area because it's not owned by the lot owner, as opposed to be given the right to use perpetually under a grant of exclusive use. So,
and just before we finish off our discussion on EU with a variation upon it, just a question there, Julia. I know you're a regular, Julia. Thanks for tuning in. How much does this cost, excluding stamp duty? I'm thinking, Julia, you're referring to the purchase discussion that we had earlier. Do you want to give a really vague ballpark, Frank?
Yeah, absolutely. I reckon you're looking at probably maybe $4 to $8 grand from start to finish, excluding stamp duty. Stamp duty's going to be nominal. It's probably going to be roughly 3% of whatever the value of the area is. So that's not cheap stations by any stretch of the imagination. But by the time you're done with drawing all of the plans, the legal contracts, the process through the titles office registration and new CMS and all that sort of stuff, which is far different from effectively a survey plan for an exclusive use area motion and then a new CMS. It's far cheaper to do the second option.
Yeah, okay. Thanks for asking, Julia. Let's move on to allocations, which is a kind of sort of variation on an EU. So Frank, tell us a little bit about allocations.
Yeah, so this is more about how these things actually get allocated. So for you to actually have a grant of exclusive use, it's not sufficient for there just to be a bylaw. What there needs to be is a bylaw that says that the owners of the lots referred to in the schedule will have the exclusive use of the areas referred to in the schedule, and there's a plan attached to it. So when you go to Schedule E, there'll be Lot 1 has area 1, 2, 3, 4, and those might be car park, storage area, courtyard. Again, we're going back to all the popular ones. You need to have all of that to make sure that it's actually yours. And we do see them from time to time where there's a bylaw that says the owners will have the whatever it is, but yet there's nothing in Schedule E. Yeah. And even one the other day, we're doing a new CMS for a client, and all of the car parks are actually on title, which is the other way you can do it. It's not the most, what would you call it, easy to deal with, because if you're talking about reallocating common property, which is because you can transfer exclusive use grants. So if Chris has car park number 1, I've got car park number 2, and we agree to do a swap. We enter into a reallocation agreement, give notice to the body corporate registers the CMS. If our car parks are on title, we actually need to subdivide them off each other's lots, transfer them to each other, and then amalgamate them into our titles, which is a painful exercise again, as we talked about at the front. So here's the trick, and this is part of what sometimes comes up in conveyancing due diligence. When you're looking to buy something, you need to make sure that that allocation is actually there for you, because it's all well and good for someone to say to you, you've got car parks 2 and 3 downstairs, and here's a car park with number 2 on it, and here's a car park with number 3 on it, unless you actually go to the CMS and make sure that there's an authorising bylaw and there's a plan, and that plan refers to car parks 2 and 3, and that refers to them being attached to the lot you're looking to buy, they're not necessarily going to be yours.
That's right.
So
there are many sad stories that go with that scenario that I've heard over time.
Did you get a lot of that as Commissioner?
Yeah. There's a lot of that sort of stuff where you have people believing, assuming, or being led to believe something about the nature of their exclusive use, and it's not quite how it worked out. We need to keep moving on, everyone, because we've still got a few more to get through yet, and we're actually seeing quite a few questions whiz through. Thanks for that. We will get to those before we finish up today, everybody, so stay tuned, and if you've got some more, we'll try and get to those as well. How about we give leasing and licensing a go, Frank?
Yeah, righto.
What is the quick distinction between leasing and licensing?
Lease is giving away the exclusive possession of an area. The license is giving the right to use it, not necessarily exclusively.
All right.
So there you go. So when you, and probably biggest example is going to be the holiday unit I'm in now. My right of occupancy here is under a license for 4 days. Whereas if I was a permanent tenant, what I would have is a Form 18 lease, and that would be then mine. So the rights to access it only come with in accordance with the lease itself. From a license perspective, in theory, the manager can sort of charge in unannounced, as much as that doesn't usually happen. Yeah. And where we see these things in a body corporate context, probably the easiest examples are telephone towers, or communications towers and things like that. Those things, when they go on buildings, normally should be documented in the form of a lease, because it's giving away the exclusive possession of that particular area where that thing's installed for a period of time. 3, 4, 5 years, whatever it is. A license of common property is normally where you see in mixed use type developments. You might have, you got the Hastings Street, there's a lot of these, units above, commercial downstairs, and there's people with tables and chairs out the front on what is common property. That is usually a license agreement. So the occupier of that unit has the right to use that area to put out tables and chairs, but it's not theirs and theirs alone.
Yep. Well,
and
well
so it's
said.
more indefinite that way. Yeah.
I thought that was pretty well explained, Frank. The nature of how you license or lease largely depends upon the duration of that, doesn't it? And so just to sort of explain what we mean by that, you require resolution without dissent to license or lease for more than 3 years, or for 10 years for the accommodation or commercial modules, part of common property. Special resolution to amend those, and also for a lease or license under 3 years. So 3 years is roughly your cut-off point for licensing, and the difference between special resolution and resolution without dissent. You can't lease or license if it would interfere with an exclusive use right to access the lot or common property, or if it interferes with an occupational authority. Bit to take in on that one, but that's an exclusion. As Frank said, the most common ones, the telephone towers, I guess we'll see more and more of that moving forward. Those leases and licenses can be granted without those resolutions that we just referred to if the CMS provides for the lease or license. So that's a bit of a quirky difference, isn't it, Frank?
It is. And it's a bit like sort of further development. So we've got Schedule B in the CMS that allows a developer to systemically stage development over a period of time if a development or staging happens in accordance with what's disclosed in Schedule B, the committee can sign and might be obliged to sign the CMS. The same applies with these things. Although as much as with lease or licenses, it's very rare. We see lots of Schedule B stuff. We very rarely see CMSs that incorporate anticipated lease or licenses at committee level. So the other thing is that you can actually charge for it. And you quite often see that. So when you've got a telephone tower, a body corporate really is entitled to disturbance costs. And in the same with lease or licenses, they are, as much as that exclusivity of possession is a little bit different, the risks involved are. So if I put my pure lawyer hat on, when you're giving someone the right to use common property, what happens if someone trips and falls? What happens if someone hurts themselves? So what you can build into those things and should consider doing is indemnities around risk, obligations to insure, obligations to provide certificates of currency, and you can charge rent for them. So again, it's not a body corporate charging or receiving some form of consideration in exchange for giving away the right to use common property, permanently or otherwise, is a normal commercial arrangement which isn't running a business. So those things, you can charge rent for them or a license fee.
Okay. We have one more type of common property usage right to go through. That's Occupational Authority. But I reckon we might tackle some of these questions, Frank, because there's actually a few of them that have come through, which is great. Thanks for that, everyone.
I can't see them, mate. So you're
I'm going to read them out to you. So Bev, thank you, Bev. Exclusive use passed for patios and double carports in 2000 without payment, but schedule was never changed. 3 units have large tracts of common property. Should we change lot entitlements? You've stumped him, Bev.
Yeah, no. I like being able to see the questions and think about it for 5 minutes, but today it's officially questions without notice. I think there's a bunch of historical stuff you need to look at there in the context of changing lot entitlements is really, really hard. And probably these things, when they're lost in time, always interesting in terms of the Commissioner's Office, where they can make orders that are just and equitable in the circumstances. So it's a bit dangerous. Well, I'd say that's definitely one you'd want proper legal advice on, because you're going to need to take into account all of the history of the thing. Because my take would be, and Chris, you can comment on this or otherwise afterwards, I think an adjudicator is probably going to be unlikely to allow a change in contribution schedule lot entitlements because of something that's been there for 10 or 15 years or more, particularly in circumstances where probably the owners who might have acquired that area or the right to use it have shifted it to someone else.
Yeah, look, it depends. Yeah, that can go either way, that one, Frank. So, Bev, I think that if you've got some concerns there, and particularly if it's having a financial implication, or it might have a financial implication, you need legal advice on that one. That's a bit more involved than we can answer right now. Gleno, thanks. I know you're a regular. Can past motions override bylaws? Well, no. You need a special, in order to change bylaws, there needs to be a special resolution in the first place. I'm not quite sure what you're driving at there, Gleno.
Yeah, and I'd start with it. The bylaw says what the bylaw says. If the body corporate wants to change the bylaw, then it changes the bylaw. But if the bylaw doesn't change, then they're the rules. So, so I think probably it's part of characterisation about whether that motion was intended to do something with the bylaws or not.
Yeah.
So again, that's a complicated legal one, because it's the characterisation issue. What is it? What was that motion intended to do?
I agree, Frank. The Maze, thanks as always for tuning in. A two-parter. I might read out just one of the scenarios. Telstra cable frame for all units is under internal stairs of manager's unit that is sold privately. What right of access does the body corporate have to ensure phone service? Well, my initial reaction to that is that we go back to our comment earlier about utility infrastructure and about how that cannot be given away.
Yep,
so
and bodies corporates. And bodies corporates have the right to access lots for proper purposes, and a proper purpose is absolutely going to be the maintenance of utility infrastructure for the benefit of the building as a whole. And you've only got to, it's interesting. We're right beside a building here that we gave advice on a while back, where they wanted to access all of the lots to redo all the windows, because one of the things that doesn't work real well is salt spray and steel or aluminium over 30 or 40 years. And a couple of the owners objected. And the reality was the body corporate could access the lots, but there's a process to go through to make sure that's done lawfully. And I'm here, and there's probably of the 8 stories, there's only 3 to go. So they're clearly well and truly underway.
Yep.
So there's a right to get there. You just got to follow the process.
And there's a second scenario there, which manages tool storage, shed for storage of gardening stuff. How do we make that available to gardener without losing control of the space in perpetuity? We've gone over some of the options today, Maze.
And we have the next one coming.
Yep. Which we might not even get to today, Frank, because we've got a few more questions. Judith, thank you for tuning in. How are utility boards protected within a titles lot? So if you're talking about what we call, Judith, utility infrastructure, I'm assuming you're talking there about the electrical board or the circuit box. That would be utility infrastructure, so that is protected. That's not something
specific carve out in the Act that prevents that from body corporate's got the right to access that no matter where it is.
Yeah, and so there's no ability for the body corporate to give that away, to give that utility board away. NOC or NOC, thanks for tuning in. How do you protect common property from damages? Good question. How to ensure repairs to damaged common property is paid by the individual that caused the damage and not the body corporate. You get an order from an adjudicator for that. First of all, you need to be able to show that they actually did it. So say, for example, a really common one is someone backs their car out and damages common property car park / driveway. In doing so, they should be responsible for that damage. Presumably you've got CCTV footage, or you've got a witness report, or something else which links them to that. But that's how it gets done. Goes get an order.
It definitely doesn't get done by simply debiting the owner's levy account for the amount the body corporate's incurred in fixing it.
And the tenant can be responsible for that as well if they cause damage in that case. Yep. Mr. SMB, as always, thanks for tuning in. Can a body corporate vote to approve to allow all future licences to be greater than 3 years to make it 5 years, requiring special resolution approval to alter the default 3-year rough cutoff? And the answer, Frank's vigorously shaking his head. No.
Unfortunately not. There's the illusion of choice sometimes here, where body corporate has a degree of self-governance, but not when the legislation specifically says if it's more than 3, it's this. There's a couple of things you can probably look at to help get you there with those things, but I won't say those publicly because that's a little lawyer trick. But no, you can't change the legislative position. The Act is the Act. Can't contract out of the Act.
Yep. Steve, thanks very much for tuning in. How easy is it to remove historical access easement coming up on current common property title search? Old easement not relevant due to new statutory road access.
There's something new every day. I would have thought, I've never taken an easement off title, but have removed plenty of dealings that are no longer relevant. My bet would be you would be able to make an application to the titles office to remove, probably on a Form 14, which I think is the general request, remove an expired easement. But you're going to need, my bet would be, the consent of the dominant tenement or the person that had the benefit of that easement to doing that. You're not going to be able to do it unless they agree. So that's probably a difficulty. If it was council or main roads or something like that, finding someone in there who's willing to sign the bit of paper to say we don't need this anymore is almost certainly what you're going to need. But ring title's office. They may be able to tell you off the cuff.
Yep. And Judith, a follow-up from your question before, can the community board legally be placed within a private titled lot, was originally listed as commercial, now claimed as residential? Well, it can be put in somebody's lot, but it's still retained by the body corporate. So it's still utility infrastructure, which goes to Frank's point before, which is that the body corporate is legally entitled to enter that lot to access it if it's utility infrastructure. I think, Judith, you or your body corporate may need to seek some legal advice on that one, because it sounds like a few things have gone on there that are not entirely clear in that particular scenario. Frank, we've come to well and truly the end. In fact, we've gone over time and we haven't gotten through all of our property usage rights. We didn't even get to occupational authorities. We might have to hold that over. This is clearly a big topic for people, the granting of common property usage in its various forms, judging by the questions at the very least. So we might have to look at a part 2 on that. You know how much we love sequels here. So yeah, stay tuned for that one, everybody. We've come to the end. Thanks so much. Great participation, everybody, today on what's obviously a hot topic. Frank, thank you. Thanks for tuning in, taking time out from the holiday. Next week, stay tuned for that one. We hit October. Gosh, tomorrow. Bloody hell, when did that happen? And our topic list for October will be out to you fairly shortly. So please make sure you subscribe, because that's how you are going to find out about it. Until next week, everybody. Frank, team,
thank you.
all. Catch you, everyone. See ya.
Thanks, everyone. Bye.
Bye.